The U.S. immigration landscape has shifted dramatically with the introduction of a new $100,000 fee for H-1B visa applications, a change that has created uncertainty for employers and international workers alike. This unprecedented fee, announced through a presidential proclamation, aims to reshape the way companies hire foreign professionals, particularly in the high-skilled sectors that drive technological innovation and economic growth. Many employers, who have long relied on H-1B visas to fill specialized roles in engineering, computer science, and other critical fields, are now scrambling to understand the implications of this fee and how it affects their recruitment strategies. The new guidance issued by the U.S. Citizenship and Immigration Services clarifies some aspects, but the complexity of the process means that businesses and applicants alike must proceed with caution and careful planning. The fee specifically targets new petitions filed on behalf of foreign nationals who are outside the United States, and it does not apply to all H-1B visa applications. Change of status cases, for example, where a person transitions from F1 student status or another non-immigrant category to H-1B without leaving the country, are generally exempt from the $100,000 payment. This distinction is critical for employers who routinely sponsor international students graduating from U.S. universities, as it provides a path forward without the additional financial burden. However, the reality is far from simple. The proclamation and subsequent USCIS guidance set very high thresholds for exceptions, indicating that exemptions will be granted only in extraordinarily rare circumstances where the hiring of the foreign worker is deemed in the national interest, no qualified American worker is available, and the payment would significantly undermine the employer's operations. Employers must submit detailed documentation to support such requests, providing evidence of the worker's unique qualifications, the critical nature of the role, and the potential impact on the business and the broader U.S. economy. This creates an added layer of administrative work and uncertainty for companies, many of which have already invested significant time and resources in recruiting top talent internationally. At the same time, the high fee may discourage smaller businesses or startups from hiring foreign professionals, potentially slowing innovation in industries that rely heavily on international expertise. The fee's impact is not limited to companies alone, it affects the workers themselves, who may face delays in processing, uncertainty about travel, and additional financial barriers. While current H-1B visa holders are generally protected, new applicants must navigate a more restrictive environment, and families and dependents may also experience indirect effects from these changes. The H-1B program has historically been a cornerstone for attracting global talent to the United States, particularly in technical fields such as software development, electrical engineering, and biotechnology. International students graduating from U.S. institutions contribute significantly to these sectors, often accounting for the majority of graduate-level expertise in STEM disciplines. Employers have relied on the predictable nature of H-1B visas to build long-term teams and invest in employee development, confident that they could secure the necessary work authorization for their most talented candidates. The introduction of a $100,000 fee, however, introduces a level of unpredictability that could influence hiring decisions, shift recruitment strategies, and even redirect talent to other countries with more welcoming immigration policies. Companies may be forced to evaluate the cost-benefit of sponsoring foreign workers under the new rules, balancing the potential value of specialized skills against the significant financial outlay required to comply with the fee. Despite the challenges, USCIS has provided some clarity on the process for paying the $100,000 fee. Employers must submit payments through the official government portal, ensuring that applications are correctly linked to the payment and that all necessary documentation is submitted in a timely manner. While the process is standardized, mistakes or misinterpretations could result in application delays or denials, highlighting the importance of careful attention to detail. For those seeking an exemption, the process is more rigorous, requiring a formal petition to the Secretary of Homeland Security, along with comprehensive evidence supporting the claim that the individual's employment is in the national interest and that no qualified American worker is available. The guidance makes it clear that these exemptions will be extremely rare, setting a high bar for success and signaling that the fee will apply to the vast majority of new H-1B applicants. The broader implications of this fee extend beyond the immediate administrative and financial concerns. By increasing the cost of hiring international talent, the policy may influence the competitive landscape for U.S. businesses, particularly in industries where high-skilled labor is critical to innovation and growth. Companies may seek alternative solutions, such as remote work arrangements, hiring from countries with less restrictive visa policies, or investing in domestic talent development programs to mitigate the impact of the new fee. These shifts could reshape the composition of the workforce in key sectors, potentially affecting productivity, competitiveness, and the pace of technological advancement. At the same time, the policy reflects a broader trend toward prioritizing American workers and industries, signaling the government's intent to balance the benefits of international expertise with the protection of domestic employment opportunities. International workers themselves must navigate this new environment with care. Those seeking to enter the United States on an H-1B visa must now consider the financial requirements, potential delays, and stringent eligibility criteria when planning their careers. For students completing U.S. degrees, this may influence decisions about whether to remain in the country or pursue opportunities abroad. The increased financial burden could also influence family planning, relocation decisions, and long-term career strategies. Advisors, attorneys, and employers will play a critical role in helping applicants understand the nuances of the new fee, prepare the necessary documentation, and explore potential avenues for exceptions where applicable. The combination of regulatory complexity and financial impact requires a proactive approach, ensuring that both employers and workers are fully informed before making decisions that could have long-lasting consequences. In addition to the fee itself, the broader context of U.S. immigration policy continues to evolve. Previous administrations have implemented various changes to visa programs, enforcement priorities, and work authorization rules, creating an environment in which clarity and predictability are highly valued by employers and international workers. The introduction of a $100,000 fee represents a significant policy shift that will likely influence discussions around immigration reform, labor market dynamics, and the role of high-skilled foreign workers in the U.S. economy. Policymakers, business leaders, and advocacy groups will closely monitor the effects of this change, potentially pushing for legislative adjustments, administrative clarifications, or new pathways for international talent. The outcome of these discussions will shape the U.S. immigration landscape for years to come, affecting companies, workers, and the overall competitiveness of the nation in the global economy. For many employers, the question is no longer simply whether to hire international talent, but how to navigate the new $100,000 H-1B fee without jeopardizing their business operations. Startups and smaller companies, which often rely on specialized foreign expertise, face particularly difficult choices. The financial burden may force them to delay hiring, limit the number of international employees they sponsor, or explore alternative arrangements such as contracting or remote work. Larger corporations may absorb the cost more easily, but even they must carefully evaluate their workforce strategies to ensure compliance while maintaining competitiveness. Human resources departments and immigration teams are now tasked with conducting a careful risk assessment, determining which positions absolutely require international hires, and which roles might be filled through domestic recruitment or alternative visa categories. The stakes are high, and missteps could result in denied applications, costly delays, and potential disruptions to critical projects. International applicants themselves are facing new uncertainties. Graduates who once assumed a clear pathway to employment in the U.S. now must consider not only whether they qualify for an H-1B visa, but also whether their prospective employer is prepared to pay the steep new fee. This has a ripple effect across industries that rely on foreign talent, particularly in science, technology, engineering, and mathematics fields. Many students may rethink their plans to remain in the U.S., potentially returning to their home countries or exploring opportunities in nations with more predictable immigration policies. Meanwhile, families of international workers may experience indirect effects, such as delays in dependent visas, additional travel considerations, and heightened financial strain. For companies that value diversity and global expertise, these developments could disrupt carefully built talent pipelines and long-term succession plans, emphasizing the need for proactive guidance and thorough planning. The guidance issued by USCIS attempts to clarify some of the confusion, but questions remain. Employers and applicants must ensure they understand the difference between new petitions filed for individuals outside the U.S. and change of status petitions for those already inside the country. They must also determine whether exceptions apply, and if so, prepare extensive documentation to support their requests. This includes demonstrating that the alien worker's employment is in the national interest, that no qualified American worker can fill the role, and that paying the fee would significantly undermine the interests of the United States. Achieving approval for such exceptions is extremely rare, and the process is intentionally rigorous to prevent abuse, placing additional responsibility on petitioning employers to fully understand and comply with the regulations.